because of some administrative reasons. Please give all the memos. We'll consider it. Only just, which cannot wait, just give. Right. Yes, we file the memo. Yes, other side. First time, no interim order. Oh, contempt want to withdraw.
And it's items 40 in your lordship's list.
Yes, let us see. Let us start the roster. We can reach very fast.
My lord, may I have your lordship's kind leave to mention a matter, please, my lords?
Why?
My lord's 27th, I was the successful writ petitioner, my lord. And on writ appeal, my
Anyhow,
lord.
tell your counterpart to give. We'll see to it.
Right.
Yes, submission item number 1.
That is Sophus notice. But and they wanted to file reply to the Sophus.
Yes, rejoinder within a week. Counter has been filed.
No, counter not filed.
So-
But here I have come against the Sophus notice. So I pray that liberty may be granted to file that reply to the Sophus.
Oh, you wanted to dispose of?
Lost.
Yes. The
And except 3 pages.
Go on for the petition. We need to permitted to withdraw with liberty to file the form.
yes, it is submitted by the counsel for the petitioner that they have that the challenge is made to and
From me,
what I said.
is submitted by counsel.
Pardon me. This is the public interest litigation. And by the village, on behalf of the villager, Adjournment.
Yes, what is that? What is your reaction? Because you have to file your affidavit.
Range of question of maintainability.
You just file, take a plea. Stop. This is a LAPO. The instant writ petition in the nature of a public interest litigation is at the PS. Dangerous. Kishore Khaitan's case of Supreme Court 2006 Volume 4 SCC read. Supreme Court has deprecated the manner of passing an status quo. No.
Item 4.
Yes.
Connected matter, when some item. We are filing the counter affidavit already filed, but I am serving copy on my land.
Given.
Yes.
In which matter you are filing?
Maritime Museum.
WPC 16916 of 2025.
You are for the state,
State.
the state opposite party. The additional government advocate.
Not one.
Yes, give a date, give a date.
4th September.
I'll just apologize, my lord. Instead of department, that is OP number 3, superintending.
Lakes, State Department, opposite. Yes, call the next.
Item 5.
Proprietorship participated in the bid.
Proprietorship cannot be affirmed. Proprietorship concern.
Concern, yes, sir.
Proprietorship firm.
Proprietorship concern. Participated in the bid floated by the.
Yes, why you are not paying the outstanding? This is not expected from you. If they have worked,
And it has come, I'll take. So,
yes,
why it has
the instant writ petition is at the behest of the petitioner seeking.
Similar matter has been.
Sir, we'll pass an order. They wanted to have instructions. No difficulty. I know what is there.
Item number 6.
Yes. Then the Advocate General is to be served. You are challenging this state legislation?
Yes, ma'am. Power matter.
180 ml.
180 ml. Yes, 180 ml. Good. Do it. Tag with the matter. Yes.
Item number 7.
7 mile also 180.
Yes. Tag with the matter.
Item number 8.
On behalf of Mr. Govindra Prabhu, petitioner in these 8 applications.
Can this be done in a writ jurisdiction that you wanted to inquire into the signature appended on the MOU? Is the writ court meant for that, for to gather an evidence for you or create an evidence in your favor?
No, I am a successful bidder. I am continuing.
Whatever they have rejected. What is your second prayer? Directing to inquire into the signature of such and such in MOU dated such and such. Is the writ court meant for this?
My representation to that effect is.
So what representation? That is your rejection has come. If you are agreed by a order of the rejection, challenge the rejection.
No, my representation is pending before the authority under Annex 3 for inquiry. They are not taking step to that effect. That is my only.
What is the inquiry? I do not know what is this. Where is your rejection order?
No rejection order, Your Honor.
You are challenging rejecting the MOU dated 8/7/2025.
No,
Where is the MOU of 8/7?
MOU has been filed by another bidder by manipulating a signature. I am against that manipulation. Nothing has been rejected against
What
me.
is your ground for manipulation? Tell me.
Your Lordship may kindly see.
What is the ground? What you have stated in your writ petition?
Your Lordship.
That why this is done?
Your Lordship.
Let us see representation. What do you say in the representation?
Annex 3, Your Lordship.
Yes, I am looking at it. What you are saying, contractor who is also a tenderer,
Your Lordship.
relevant documents in such and such in the same identification. How do you know?
Your
It is only the Deepak Ranjan Nayak who can come forward and say that my signature is forced. Who are you to say that he has forced?
Your Lordship, it is clearly apparent document itself.
You are expert? Are you a handwriting expert?
In this way, the other.
This way means it is only the Deepak Ranjan Nayak whose signature you allege to have been falsely made or is a false signature. He should come and say that this is not my signature. You are a third party to this, and you are claiming this.
The other eligible person who.
Sir, that you are so jealous.
No, I am.
You have no ground at all. Madam, who can say signature is false? It's the person whose signature is appended on a document. He is the person who can say that this is a false signature. You are third party. Do you know the signature of that gentleman?
Your Lordship, I have
Do you know
PAN card of the person.
PAN card contains, are you an handwriting expert? Can you say that this signature is his? By passage of time, sir, the signature varies by age also. That's why the bank at times wanted that you give your correct, the present one. Why?
Even in different circumstances, one may
It
put
may
different,
be different.
in different circumstances.
No, can't be. This is the fancy litigation, sir. We will not. Will not. It's a fancy litigation. Even against the Evidence Act.
Let authority decide the.
Why? An stale claim, can the court direct authority to pardon? You know the Supreme Court judgment. Supreme Court deprecated that the High Court should not endorse the litigation by referring the representation upon the authorities to decide. Where the High Court is also sanguine or came to a finding that this cannot be tenable. I'm asking the merit. Is it tenable? If this the Deepak came forward and said, no, this is my signature, can you?
inquiry be undertaken?
Why, sir, merely on your apprehension, that is the third party. You have no knowledge of the signature. You do not know this gentleman. You have not seen the person signing before you. Under the Evidence Act, when the signature of a particular person is proved, how it is proved?
The expert or by the person who.
Why, sir, unnecessary? And suppose if it is found that it is the genuine signature, what will happen? Imposition of cost. Then we are writing it. If you are so sanguine, we are writing it that in the event the handwriting expert corroborates, or the gentleman whose signature is offended comes and admits that it is a signature, cost you have to pay.
Your Lordship may grant me liberty to, while I will withdraw this with the liberty, let the person appear on his choice.
Why this is up to him whether they will go. There are so many allegations which are coming. How do you know? You have not spelled in your representation that you know the signature of this gentleman. You have seen him signing in front of you many a times.
This gives
Nothing has been spelled. Simply you say that this gentleman has made a false signature. No, sir, brother, this can't be.
I may
This
want
cannot
to
be.
withdraw.
This is up to you. File a memo. Law is against you.
Filing it and intention to stop the corruption I have filed.
This is not a corruption, sir.
Madam,
It's not a corruption.
you are not filed Opalakam and properly
Who is filing Opalakam?
your name,
No, on behalf of.
you have not mentioned them while beginning.
Who is filing Opalakam?
Somebody, Jagol.
Yes.
Where is he?
He is held up in some other.
You just bring him, let him file.
Your Lordship.
Thank you. Yes.
Item 9.
Pass over.
Pass, please.
Right, and then 180. Too bad.
This is a case of civil law. And civil law.
Item 10.
Which one?
I don't care.
Have you seen that?
No, it's not me.
But
Let's be examined.
No, you are relying on this. This is not a covered matter. So this bench may take a dissenting view. Yesterday I took, rather we took a dissenting view to one judgment and referred the matter to a larger.
Yes.
So you can't. This is what you are relying on. This is what the law has been held. You have to argue, sir.
that apart, my lord, yes, that says the order allegedly to have been passed by the townsman, but as a matter of fact, the document says it is mining officer.
Where?
Yeah, it is also the mining officers also rendered the.
It is annexed 2 at page 20. Relevant portion is at page 21. Mining officer Cuttack Circle. In the entire
Yes.
case it has been passed by the Tahsildar. So it doesn't have any jurisdiction.
Sir,
After that-
where he has stated?
Missing paragraph 4, you can see the paragraph 4 also
Yes.
of the order.
No, it was handed over to the mining officer. He has said in paragraph 9. They have to pay 1,07,000 rupees. You wanted a compounding of an offense, they have done it. Will you not pay the amount? Will you not pay the amount while compounding?
Because it directs to release the vehicle.
Sir, will you not pay? Then how they will? You pay. If you do not compound and comply, how are they obligated? Then the adjudication has to be made. They agreed because you prayed. I have seen in your pleading, you said that you wanted to compound the offense. Please release my vehicle. They have compounded, demanded 1,07,000, pay off. Get the vehicle. They will release it, definitely, because there will be no case. That's the law, sir, you know.
Identical issue also to implement addition to release the vehicle.
No, that is, I am dead against that. If the vehicle has been apprehended or seized
There is clear
in terms of a particular provision of the act.
Mr. Counsel,
Yes, sir.
the
There's a
Tahsildar has seen.
But here the mining.
Here mining officer, who is a competent authority, there Tahsildar has no jurisdiction. That is this subtle distinction after amendment.
Here also the issue-
Mr. Counsel, you have not made out any case for without jurisdiction or lack of jurisdiction.
And I was not compounding the offense, Lordship. The allegation of the mining officer.
Sir, the thing is that now we are not really activating that concept of a plea bargaining, which is also one of the concepts. But it is a case where you wanted to compound the offense because you are not ready to go and face the trial. You say, whatever, I have compound the offense. Now they have compounded the offense and they have imposed certain that if you pay this is the compounding, they will not proceed, no case, everything will go. The moment the case goes, then the retention of the vehicle will be improper. Because they cannot retain without any process of law. The law goes, you pay.
Same issue, that there is violation.
That was a Tahsildar.
Tahsildar.
That was Tahsildar. After the amendment, it is a mining officer who has been interested. In your case, it is all the mining officer who has done that. And it's a mining officer who has issued the order of compound. Not the Tahsildar. Had it been a case that the Tahsildar has used his power after it is taken away by way of an amendment.
The identical of the mining officer have taken the
No, it is a Tahsildar which is taken.
running paragraph 4 of
Sir, here the prayer is quoted
Yes,
in
sir.
the first paragraph. That honorable court may graciously be pleased to admit the writ petition and issue notice to be said, call for the records. And the illegal seizure dated 6/2/25 by Tahsildar. And 2022, the amendment has been brought, where the Tahsildar's power is taken away, wasted upon the mining.
Was there a proceed for the Lordship? We had penalty thereon by the mining officer under Annex 3. Because here the mining officer had seized the vehicle and hand over to Tahsildar.
That is
My
the
issue also similar
seizure,
to
sir, custody of the vehicle and the seizure of the vehicle are two different concepts.
Lordship. Now it is.
If a person has a power to seize the vehicle, it seize, and then for the purpose of safety, give a custody, that does not mean the seizure goes.
In the identical case,
No,
Lordship,
sir.
this
This is
seizure
not
was
a-
paid by the, as per Annex 3
You
of the mining officer
or we
and
say
the
that this
Tahsildar
is
is
not
custodian. And the same issue also in my case, Lordship. The Tahs-
That was not first time.
Ponder upon the thing, otherwise we are going to, if you want, we can decide it here and now.
Another Lordship.
Tell me, where?
One paper.
One thing. Please consider this. Come with the relevant provisions. Consider.
Item number 11.
This thing for the page 41, the order of contract, the petition is continued. The date of closure of the contract is 30th September of this year. Let's see.
What is the date of the tender?
19.
Where is the tender?
The phrase tender,
Annexure 1?
another one is
Yes,
the
ma'am.
continuance.
Page
Yes,
13,
sir.
Annex 1.
Page?
31, Annex 1.
Award of contract is at page 41.
The tender has been finalized.
It is continuing in the pursuant to this tender, the petitioner is continuing the actions.
So I do not know what actually is this.
Pursuant to this.
You are challenging that particular tender, certain clauses of the tender, unconsignable and contrary to Article 14 and 19(1)(g). Now tell me that whether you participated in the tender? In this tender?
Receives the first tender, pursuant to which,
Say the previous tender.
yes,
Say that previous tender, you were the successful bidder.
I am continuing.
You were awarded a contract. The contract was duration.
30th September 2025.
Now they have issued a
Another
tender.
tender has been issued.
Correct. So
But
they
why-
will finalize
Yes,
and definitely they will award the contract to a successful bidder after your expiration of the term.
My submission before a lawsuit is that if good amount of money is held up by the authority and moreover your lawsuits, the petitioner is also has filed his willingness to continue to work with the same terms and conditions. And that is an answer
It
six.
is a
It is not-
constitutional right,
No,
because
it
madam,
is.
let me
No.
understand.
That is not the right of the petitioner. But my submission before, let's say that when the petitioner is working, and that is the clause at page 34, let's say, that the authority has a right to, that it will be mutual consent, with the mutual consent, they have every right to consider the presentation of the petitioner, only
Presentation means?
representation, that is a
Representation is not, but which one is the clause?
page 34, clause 11. Page 30, I'm sorry, page 30.
Where is clause 11? 30,
Yes.
30.
Yes, sir, six. Clause 11.
Yes,
The second,
yes.
the agreement may be extended on the same terms and conditions or with some additions or modifications for a further specific period limited to 1 year mutually agreed
So
upon
it
by.
is really a contingent on the terms. So if they do not agree and they wanted to float a new tender, then means that they are not agreeing for.
My prejudice is pending. So
Sorry.
let them decide
sorry.
on that university.
That is up to them. Their decision is very clear.
They have not decided. It is fixed.
Madam, they have floated a tender.
After that, I have filed
Correct.
my petition. I have filed before them after this. Another 6 is pending. Let them take a decision on that.
A calculated chance is taken by the petitioner invoking the
Item 12.
Sir, 5, challenging my order of confiscation of my vehicle.
Confiscation by whom?
My lord. Lordship is here.
Spurious or spurious? They were the spurious matter, the IMFL
IMFL also.
or genuine but without any bill invoice or.
Not genuine. Your lordship will find from the order at page
No, there is a
28.
distinction. It's a spurious liquor or is a genuine liquor, but without following the rules of law.
The petition filed, I don't have any introduction, but from the amendments, I find that it is spurious.
Take an instruction.
Yeah.
Fine. Not complete. If it is spurious matter,
My lord, one thing.
I have the strongest of the.
One thing I have to submit, my lord. Well, they have seized my vehicle, my lord. I have taken loan and I have purchased the vehicle, my lord. They have not issued any notice to the tenants of my lord.
Are you a carrier or a
But
transporter?
no, my lord. Thing number 2.
I am asking, are you a carrier or a transporter?
No, my lord. I am a only driver and I am living.
Fine. 1 week comes. Call the next.
Item 13.
Yes, 13. Who is the peer?
Item note 13. Sir.
What is the matter?
This is a fully extraordinary matter.
So requires an extraordinary and exceptional decision to be taken.
No, it's just why it's extraordinary. It should be used. It is really a matter extraordinary because it seeks to penalize me for following the law and for not doing the impossible. And that's the notice and the challenge. Let me explain this very briefly. Please turn towards the list of dates. There's 3 or 4 dates in the list of dates. It's a very short list of dates.
Yes.
The way I explain the issue, Mellis. The issue is that we have a mine. The mine, Mellis, has minimum production requirements. There is no dispute on that. We are following that. We are, Mellis, a leading company which has no default of any kind here in terms of the normal demand. Much later, a rule comes which imposes a dispatch requirement, which says not only minimum production but minimum dispatch. That comes after. Well, your lordship has done other matters here. In the High Court favors other matters are pending, and it comes after a process is started to limit my production by the mining plan. Plan is statutory. Mining plan has been given the force of statute by the Supreme Court also. The mining plan can't be violated. For a variety of reasons, from X to Y, the quantum is reduced. Yet, under the separate 12A introduced much later, you are required to dispatch the same on the same basis. On that basis, a notice of demand comes, which is under challenge today, which says, give me these 1,000 crores for the year 23 to 24 on not being able to dispatch. Now, my mining plan says dispatch 10 units. Produce 10 units. Your dispatch plan says dispatch 25 units. That's why I say it's a situation where the left hand and the right hand are not in sync. Now, there are other writs pending. There is a writ here on the same issue where your lordship has given a stay. There is an earlier writ by me for an earlier year where the amount was small and a small amount was asked to be deposited. But when that order was passed, 3 factors which are present today were not available, which make it stronger in my case. And let me now start in that context, the list of dates, then your lordship will give the 4 points. The first of which is complete denial of natural justice, not even this process of hearing. So in any case, the time being, this demand is void. So just see the date. 22 January 2020.
This is a central legislation. Your second prayer.
Yes.
Second prayer is a central legislation.
Yes.
Then I think the Attorney General has to be noticed.
That is your lordship's given the
Or ESG here in the state.
Yes.
Or DSG, I do not know.
DSG has been appearing and go out.
There's no ESG here.
No. Yes.
CGC and the panel council and DSG.
Then the notice has to go first.
Mr. Arnav, Yeah,
Last demand.
Sir.
you have served copy on.
Yes. Yes.
Oh, that is a UI,
The Union Opinion.
but has to go to him as well. Has to go to him also.
It's delegated legislation, not the section.
Oh, it's, that is, no, that's a delegated legislation.
You are actually for
Delegated
union.
or I
I
don't
am
know.
appealing on behalf of
Union.
the union.
After all, it is framed by the central legislature.
That's true. Well, for the final hearing, a lordship would have that. I have no problem. They will have replies. I am just seeking some protection because this is completely void, asking you to comply with the dispatch when the
No, I
final plan is
understand.
zero.
When you have limited the production, then you cannot enhance the
That's right.
dispatch.
So it's
That is
impossible.
very-
That's something I have to go into some details. Your lordship may do consider one thing. Lordship may have it called out at 12:15 after the short break if your lordship so minds. And the management can come and you can spend 10 minutes on that. I like to argue to short while tell lordship that position and let him come by then, but if he doesn't have copy, you give another copy right now.
Please. I run Seizure. This matter may be taken up at 2 p.m. so that I can know. It's 2
I mean, it's difficulty, but it's 12:15 maybe better.
Right.
Just come after the break.
Why 2 p.m.?
Request also London AG to be present.
Yes, can I take a lordship leave for 2 minutes because the Supreme Court has directed a matter? Come in 2 minutes. I'll come back in 2 minutes. But your lordship may consider if he wants time at 12:15. I'm here, I'd like to push it. In terms of the
Come at 12:50.
12:15. No obliged.
And the production.
Supplement is in this. Yes.
You have that order. You have
Yes,
that order.
ask this order again.
So I think let it also be tagged with that matter.
Yes, that
Then
match
argue.
that may be tagged. May have it at 12:15.
Same statute that other than atomic energy.
Only that one was of 2024. And they approached this honorable court nearly after a year. And in the present case, the demand has been issued on May 7, 2025.
Lordships may kindly see the other order that has also been passed.
But the demand has been raised as per the statutory provisions.
No, that's true. What he then is ceding that statutory provision because there is a
Notice
notice
has to
which he
go
wanted
and
to
counter
highlight
affidavit is required to be filed.
that in the act, you says that this much of production, once you have restricted the on quantification of the production, then you can enhance the dispatch because what cannot be excavated may not be dispatched. If there is the disparity that the excavation is more, dispatch is less, I understand. When excavation is less, dispatch is more, how he will meet? From where?
In that case, will also have it now. I'll take 10 minutes now. I won't take 1 minute. Just allow me. Lordship will be shocked. Let me before Lordship
No, there
passes.
is already an order passed by us
So well, that order.
that in that matter,
Yes, correct. There is order passed by your lordships. Mine is a for sure I do that. I'll take 5 minutes. So well, it's both amused and shocked. I don't mean to say it. Subject to my lord's discretion whether your lordship finds it. Just give me 2 minutes. Just turn to this list of dates. List of dates. Now, This is absolutely with the left hand not knowing with the right hand is just asking for demand. That's why Lordship gave a stage there, but mine is for sure that order also. It's 2 minutes. Well, the NIT is given in 2020, item 1, when we get the mine. In item 2, non-captive mining comes under the amendments. Lordship may ignore that. Only note the note NB. 1(3) of the amending act provides that without prejudice to the effects of the amendment being made by the amending act, the said amending act would be deemed to be repealed after the expiry of 60 days from the assent. One of the points is that the rule they are applying is after the expiry, it not apply. That's a final hearing point. But just note that point. Rule 12A is inserted introducing a minimum production obligation. Now, this is the point your Lordship will note. NB, no dispatch obligation. I hope I'm
Yes.
so that's 2020 March. I execute an MDPA, which is known as the Mine Development and Production Agreement. Clause 10 gives me an obligation, and Lordship in another judgment in the Supreme Court have held it to be statutory, that I must produce exactly as per the mining plan under this MDPA. Otherwise, I'm violating the statute. Schedule D in that mining plan gives your Lordship the minimum production requirement. Average annual production is given as 1.7. Note that figure for a minute, because that's the figure on which they calculate dispatch. Minimum production target is 1.36. The government of Odisha executes the mining lease for me on item 6, fellows, much after the expiry of 60 days from the assent. The government of India introduces this 12A. Now, this is for the first time that your Lordship gets in June 21 a minimum dispatch requirement. One of the points is beyond the 60-day, etc. It's not applicable, etc. That's now, Millets, in item 7, there is a challenge. Forget the amount was for a particular period, 613. Item 8, I write a letter saying open cast mining is virtually impossible in Sukhinda. It would not be feasible for more than 2 or 3 years. Next page 3 top, therefore allow me underground mining. Right, Puras? Item 9 says that 1.7 MT, which is 17 lakh, is just not possible with open cast. That's how it gets reduced by the MDPA through a process. So one of the Lordship will note 8 and 9 are correspondences with the central government official statutory authorities. So 8 and 9 is that. Item 10, I apply after the correspondence of 8 and 9 for modification of my master plan, because it's impossible to produce 1.7 million. I can't produce. Why will I not? I will be benefited by production. I can't produce, so I have to apply for modification. Now comes the most important document, item 11, which is 2022. The modified mining plan is approved for the year 22-23 to 24-25, which is the year on which this demand has come. This today's Lordship writ demand is this demand for this period. Now, this is with great respect to 1/3, 0.6 MTPA. My Lord has got 1.7 MTPA and now we're down to 0.6. Now, this is not reduced by me unilaterally. I have to follow a procedure. I have to write central government, statutory body approves it after a lot of those things. And they give a schedule. I'm not going to details. Now comes, the demand notice, which is for the current year, 7 January. This is the impugned. My Lord has got item 12. This is the, I'm sorry, there's a natural justice point here. This is the first notice. Give me a minute on this. On this, it is enough for Lordships to allow the writ. I will not exaggerate, but I may be exaggerating, Lordship will judge. On this item 12 alone, you will allow the writ. They give me a so-called demand notice. It's not a show cause. It's a demand notice for 23-24 for this amount of whatever is 1,563 crores. On the notional point that 1.7 you're not dispatching. I hope I'm clear with this. On that, you have to levy penalty, NMT, etc. Now, Minister, I make a representation on 13. This is the natural justice point. This is completely wrong. You can't do it. I have only 0.6. I say everything. They keep silent. They don't discuss my representation. They don't reason it. They don't respond. No show cause, no process, no hearing, no calling me. Next item, last item is the Lordship impugned document, which is that earlier item 12 is enhanced and escalated to add insult to injury to 1900 crores. That's what I'm challenging. Therefore, my submissions would be, to just summarize, it is in any case void under Lordship's natural justice point. If a Lordship will just take the other note, this will not take more than 5 minutes more. Use the second note. Come on. Have it ready. It's void because of natural Lordship has an elevated natural justice point to Article 14 now. It's been made as part of natural. Now, you give me a notice for not a small amount. I respond with reasons. You keep silent for 6 months. You then pass an order. Just see what is the first point. Para A.1 to A.5. This is just for convenience, fellas. Just page 3. Come to page 3, fellas. Page 3. My Lord has got it. Fellas. Now, fellas, it has first A.1, not preceded by show cause, no personal hearing. Then, my lords, in A.2, I tell your lordships the earlier notice which came for 1563. I made a representation on 28 January. A3 is the proposition. Surely the opposite parties afford any specific show cause, nor afford any right of personal hearing. Instead, they raised a revised demand of 3.7, increasing the amount to 1900 crores. This is Raman has got this para. Then, Malas, I've given the law on the next page 4, or should we just take Canara Bank and the lower judgment, Asit Kumar Kar. Well, now a lot more, I had the privilege of assisting the court in that matter, where you were declared a fraudulent account. And in that matter, was clearly there was NPA, there was fraud. As it's understood judgment, he held that facts may sound this is there about fraudulent account. We have to give natural injunctions. That's a reported judgment. Agarwal's case. So on this point alone, if your lordship has this as part of natural, as part of Article 14, it's arbitrary, void, etc. That's point 1. Point 2, Malas, is the point about doing an well, just note 3 points here in B. Don't read it, but just give me 30 seconds. A, asking me to do an impossibility. B, penalizing me for complying with the law. And C, compelling me to violate that law. They are the points in B. Now see B.1. I am permitted 0.6 from the 4th year onwards, and you are penalizing me for this 4th year itself. That's my B.1 months. B.2, as per 5.2b, the mining plan is the foundational document that stipulates the manner in which scientific and sustainable mining is done. This is further made clear by Rule 11 and Rule 13, which postulates the mining operation must be in accordance. So, that's a statutory obligation on me. Then, your lordship has held in common cause on this mining plan, which I was saying earlier. It is extraction without lawful authority. In fact, you are a trespasser who's extracting the extra amount beyond points. Then, the modified plan is not self-approved by me. It goes through a whole process as B.4. And IBM, your lordship knows, is a very, very well-known, almost as well-known as the tech company in USA as far as mining is concerned in India. The IBM is a very revered, old institution. Indian Bureau of Mines, only scientists and experts that will come in statutory body. Then B.5, I give the figures. Basically, I'm saying 1.7 reduced to 0.6 as per the mining plan is B.5. And I come on the next page 7. I apologize for doing a bit of speed reading. You will show only a flavor of it. Next page, I give the law. Your lordships do not have a situation where I can be compelled to perform an obligation which is impossible. I've given the judgment. We don't require a judgment, but I'm just saying so. Well, I have also made the point, before I end, there's one very point I want to make, then I'll end in 2 minutes. Rule 212A is ultra vires because, just come to page 8, the middle. This rule which you're applying, this your lordship may defer for a final hearing, but this is clearly ultra vires for this reason. What happened was in page 8, middle, small Roman 3, these were the amendments passed to the MMDR Act 4B, 8B, and 13.2. Because captive and non-captive were both expiring and being put to a certain year. Now let us come to para small 5 at page 8. Section 1.3 of the amending act provides that without prejudice to the effect of the amendment, the said amending act would be deemed to be repealed after the expiry of 60 days from the presidential assent. This is the 60 days point. The presidential assent came on March 20 and it expired on May 20. It's page 9 top. Therefore, any delegated legislation required to be made in 4B and 8B had to be made prior to 12.5. 12A has come after 12.5, it is common ground. The very rule you are asking under is possibly on a final hearing, non-est. Because it is not, what your lordship takes a view on the final hearing, and this point is there. This rule. There is one thing, and before I end, is important. One order is the order which your lordship will just take up, which your lordship has passed. Similar matter. Actually, mine is A for sure, because I wrote back to you, did not reply, etc. This is a lesser matter, your lordship gave a stay. Just see this. Your lordship gave a stay. Now, please just see only one paragraph. Your lordship has noted the submission. But I have something else to tell your lordship before after this. Just come to this one. all the submissions end on 5.2, come to 5.3. I'm sorry. I'm sorry. Apologies. The submissions are in para 3, Mr. Chevama makes a point similar to this. MPR was much higher than annual production of the end-use plan. He makes a similar submission. Para 5, he says that since the penal provision came on 1st July 21 and the period for late is for the first year, which had already expired, demand is not sustainable.
That's true. What we noticed from the last officer was, as you are well aware, now the apex court, innumerable judgments have had the concept of providing reasons while passing an interim order. And this is indispensable. It cannot be done. Here in this case, there was nothing. Simply recording the submissions which were advanced before the court. Since they asked for a time to respond, and the court surreptitiously jumped to the conclusion that the interim order is to be given. That's why in a subsequent order, this was placed before us. On that score, we say that unless we are satisfied, a prima facie case for an interim order, we should not pass an interim.
This is the order, Wallace. Your Lordship's order dated.
But yeah, the last portion was why we did not. That I think Mr. Chidambaram said that
delay.
no, it was in 24.
Delay.
Date they have not taken in.
Your Lordship's point was delay. Therefore, delay is now in my case, what they are saying is that in an earlier writ by me for the first year, your Lordship, they have not said yet.
No, I understand. The only thing
your Lordship passed an order paying some money. No, your Lordship is not one thing. Your Lordship did pass an order, IFPL to pay some money, but this present case has 4 subsequent developments which your Lordship did not happen in that case. This your Lordship may note, please kindly.
That's true.
Yes.
That in your case, there was already an application for modifying the particular plan. This modified
Which was not
plan-
there. So MDP was modified.
That is a distinction. The modified plan was given.
True.
And now the question is that this modified plan will operate retrospectively or from a prospective plan.
And second,
What is the first thing which we have to understand?
we'll be concerned with the prospective. The modified plan, please apply prospectively for a minute.
Correct. And
Even then we are covered.
So far as the previous year is concerned,
That is not here today. Today's writ is
no, your modified plan was the year
22.
Oh,
My lord
22.
is concerned with 23,
22.
sorry,
And this is
24, 25.
23, 24.
So for today's writ, my lord was concerned only with the modified plan, which is 2 years prior. And you are raising a demand, Mr. Department.
This is what is a distinction.
That's one.
there.
That's one. Second distinction, there's one more distinction. That earlier order was passed during the existence of 12A1 and 12A bracket 1A. The expiry on that 60 days thing has happened. This order is passed. If I am right on that 60 days point, there is no 12A. Well, my learned friend is invoking this demand on the basis of 12A. When he passed that first order in my first writ, 12A did exist because within the time period. Today, if I am right on that,
To understand,
it expired.
when it automatically lapses or expires by virtue of an operation, then in that event, it cannot be resurrected by some other means.
And thirdly, Narebom is an order in principle, I think, accepting what I am saying, the different factor there. So the third difference is that in Narebom, Lordship is passed, Lordship may not give him relief because of delay. I have nobody can allege any delay in my case. So on these points, a matter which is completely mindless and putting it on me 1900 crores and I have no default error. I am contributing hugely. I am not a fly-by-night operator. I am one of the most well-known companies. I have contributed very faithfully to every part of the collection of revenue in this state. Only thing is, this is a demand which is fanciful, saying you did not dispatch 10 units and you could produce only 2 units. I can't comply. And by the way, subsequent to that, in view of open not yielding the quantum, the mine is closed. Subsequent to that. Look at the repercussions. In January 25,
So
with
you
permission.
applied for further going deep into the mining.
No, that requires a long time. They have to survey and then they have to find whether it will sustain.
Have they considered or is it still pending at their?
No, the mine is physically closed. A surrender is in the process because apart from closure, you have to have a formal surrender. But the implication of this is that after surrender also, I'll be standing before my lord saying you're still asking for dispatch obligation. if this principle is correct, then theoretically you can ask that obligation every time. Because what he's saying is that this is a separate box on the west. I'm not looking west. I'll only look this side. This is a very unreal situation. And it stays your lordship about arbitrariness, Article 14. This is not. So, and in any case, on the today's point, your lordship has a shorter point. No show cause, no process, no natural justice. Therefore, that part should lead to a protective order, and then your lordship will consider what he wants to say or reply, etc. And nobody can run away anywhere because we are here. If your lordship feels otherwise in a later date, because we are there to cover up. Between now and when the batch is coming on 2nd and towards September, it should be no coercive steps against people. I'll be requested that DG will appeal in this meeting.
Oh, that requires, because these are the points which requires consideration in that regard. So we have to hear, and there are other batch of the petitions.
Those are
which are
posted
really.
to 2nd of September.
So we will definitely hear this point because this point appears. I must express as my genetic effect goes. I express my mind very clearly because what I feel is that is more fair and transparent manner of adjudication. Unless the lawyer or the members of the legal fraternity knows what is passing in the mind, may not be correct all the time. So that there is a chance of correction. So that's why I always, there are some points may not be so much convincing, but there are certain points which appears that those have to be followed.
I think everybody in the bar believes there is speaking together than the old phrase, well, the inscrutable face of the Sphinx.
True.
Inscrutable face of the Sphinx.
That's true. That's true. But there is a cascading effect also. The moment the more interacting jar comes, it augments the adjournment. Let me consider on this aspect. Let me ponder upon this.
After lordship finishes the matter, I tell your lordship a very interesting anecdote with Mr. Rani Palkiwala and Keshwaranand Bharti on this point. But anyway.
Yes, what to do? There is a fix on 2nd of September, so let it be taken up on 2nd of September. Take it. And the virus is already there. You have been using this, the counter in any of the matter.
So far as virus is concerned, the central government has to respond to them. Because the central statute is.
There are short instruction results in the earlier matters yet to listen.
To the more they have not filed counter, they should not take coercive steps while they have not filed a counter, not given me a reply, nor a process, nor a hearing.
Coercive steps are concerned, if your lordship will look at the impugned orders, that is at 57. Although it is issued in terms of the statutory provision, but the demand doesn't prima facie appears to be.
No,
it is only a request made to
the dichotomy between the main clause and the subordinate legislation clause. It is irreconcilable. It says it's impossibility because if the production is restricted, then the dispatch cannot be more than the production. This is something which is very logical. It appears that how can, if you do not produce, how can you supply? Strict, very common sense. So this is what it appears on that particular common sense, that you cannot really create any bridge in between that. If there is a higher obligation of the production, the dispatch is lower, I can appreciate. There is no difficulty. And secondly, they have already got the modified plan where the barrier which has been put, that has been lowered down from 1.7 or 1.3, 1.6 to 0.6. So now, if it is done, then can you still fall upon that 1.3 or 1.7? Because the Indian Bureau of Mines, I think they are the
2022.
They are the authorities. So how can it be done? These are the things which are really apparent. We will not make any comment so far as a automatic lapsing, or I do not want to make any comment of that. Let us see.
Come on 2nd of September, so that.
See, that is then forbear from doing something in between.
Presumption is always in favor of the statute, and all the action.
No, the things are, there are many things which has come out.
Yes.
But can you do it? Can you go by this and defy? That's the whole thing. If the modified plan was not there, I would have appreciated. But that is there and their production is reduced. And in that event, what?
If the Lordship will look at the impugned letter, impugned order, that is at Annexure 57.
That is on the basis of 1.36 or 1.7, I do not know.
But that
But
prima
but
facie
the
reflects-
modified plan was already there, and
Right.
that is the authority to do it, modify the mining plan, and they have reduced it 0.6.
that prima facie says that a request has been made to.
No, that has been modified, he says.
Yes,
Must be there. 22.
22, 7,
Page 332 is the modification. A very detailed one.
Yes. They have done it on the 22nd of July to 2022. Annexure 23.
Point 0.6 MTPA.
Yes, 0.6 MPPA. And that too for the year 2023, 24 and 24, 25. And this modified plan has been revoked.
No, it was revoked, but the revocation was withdrawn.
Where?
Where is it withdrawn?
Oh, 8-1, please.
Well, it's
Yes.
8th January
Oh, yes,
2025, page
8-1,
418.
8-1-25.
418.
The serial number 3 of the note.
Correct.
So how can it be, sir? Yes.
I can only pray because we are on the first day.
No.
So, your Lordship allow.
Till 2nd of September. It's not that far. We are already on 14th August. And till date, you have not taken any steps. And this, when is the letter of or the notice of
Is
demand?
that
July.
57, page 435.
Yes.
No, as the demand was 7th January. I wrote back, they kept quiet 6 months, they were 3rd July.
So this is what? So,
But if the
you
Lordship will
can
look
look
at
for 15
look at
days
that-
more. 15 days more, and it is fixed on 2nd of July, September. And we are fixing all these matters at 2 p.m. so that there will not be any other matter and decided on that.
Yes.
The
Between that, matlab, only I can pray.
writ petition
There is a request which is a command.
This is what usually happens when a request is made by the High Court to us, district judiciary. They are always treating it as a command.
But they don't dispute that this request is a statutory request. And
No,
statute is
this
the
is-
subject
this is
matter
what
of
they
challenge.
say
It
is
is yet
that-
to be declared as.
That they say is there when on the touchstone of the doctrine of impossibility, they are also acting upon. And secondly, the factual, on a facts also, when already the plan has been modified and the production is also restricted, then in that event can do. Because it will impinge upon the virus of that particular provision. This is what is.
Yes, and it will not really affect you. I should be saying no coercive steps in the next state, but we are not far away and management is not. Because in that sense, there's a distance. They've not filed counter there, they haven't given me time here, nothing will.
The
Not really, but they have, which,
there is
which
a-
quantum they have taken into consideration for quantifying the amount.
Oh, I will pass the order. Because the moment I will go on dictating, there will be.
No, your lordship, I'll
uh,
leave it to my lordship, but whatever my submissions are.
What I've said. Yes.
Other matter is finished. The Lordship will not take it remiss. The Lordship mentioned speaking judges.
Ah,
There's a very interesting anecdote.
a
My IA number 4 of 2025.
Item number 19.
Item number 19, your lordship, I'm praying for an adjournment on behalf of Ms. Guman. Your lordship, 4 weeks after she met with an accident.
who?
Ms. Sucheta Guman Singh.
She's the advocate in the court.
Your lordship, she's having the power.
The evidence report of the Petition has met with an accident. And is unable to attend the. Because on such ground, the information is sought.
20.
May I please propose? Next matter which challenges to section 73(4)(b of the Service Tax Act. The lordship has and the matter is pending before the Honorable Supreme Court.
We have been admitted till Supreme Court.
Mal.
Yes, next.
The sub-item 5.
Pass on.
4 and 5 are for the same petitioner.
Yes. Next, 21.
Item 21.
No, there are sub-items also. They are all 73(4)(b, except my lord, sub-item 3.
What is that?
No, that is, my lord, relating to the delay of the state, my lord, in filing the GST appeal. My lord. Here, my lord, sorry, my lord?
3127.
That is, my lord, 32127. The lordship kindly permit me. Here, my lord, the state is supposed to file the appeal within 6 months, and thereafter, my lord.
Condominium has been done.
Sorry, my lord?
Condominium has been done.
No, my lord. That's my problem. Now, without condoning it, a hearing notice is being issued. The last date was 5th.
In this case, 6 months, there is only a delay of 13 days, your lordship.
No, my lord.
Whatever is.
That 1 month,
Due
1 month.
condone the delay.
Yeah,
Your
we have already.
Your lordship have admitted similar matter.
State has filed for appeal.
Your lordship.
Against the adjudication order.
Your lordship.
There was a delay.
Your lordship.
Is it not your duty to give a notice to the other side? Before hearing, you cannot undertake final hearing.
Your lordship would
But
appreciate.
he has to have a say.
And there's no application filed, my lord.
You should notice for final hearing.
And there's no application for condemnation. I'm sorry.
Your lordship, in this case, department has due the petition and file an appeal as per the order. There was a delay of
That was biggest.
on the department side,
So,
and they are prepared.
Now I am dictating that what is the effect of a limitation being brought from the statute.
Your lordship, there is 1 month time also on that ground. We are filing that petition before the commissioner appeal.
What?
For that, I have to take instruction. They have already instructed me. We have already moving a petition, condemnation petition before the first appellate authority.
You can't proceed with the hearing.
No, the hearing has been fixed for several
Fix
matters.
the hearing.
I'll be taking instruction.
And my lord, that, my
When-
lord,
when
Private
is the
First
date? When date?
15/7, my lord, I took time on that date, the next
Yeah.
day, your lordship, you see,
May
that
I-
matter, item number 15, my lord. Item number 15 at the 3rd page is the petitioner's case, my lord. He's giving a batch. Item number 15, my lord.
Yes.
Madan Sahu, my lord, your lordship. I tick mark that I've tick marked his name, my lord.
107.
And he's proceeding, my lord. So he's proceeding for the personal hearing, my lord, without condoning the delay. There's no application for condonation or delay filed, my lord. And similar matters that are pending, my lord, I've given an order to your lordship, my lord. And the honorable bench was about to dispose of the matter, but gave a time to the state to respond.
In one go, at one go.
At one go, my lord. Your lordship would see.
All the appeals have been taken up from.
Yes, my lord. That is the list. Your lordship must see the heading. 15-7, around 20 appeals have been dismissed. No.
All are.
No, my lord. All are different. But your
Condemnation.
condemnation. It's not for condemnation, my lord. It's for personal hearing, my lord. So it prima facie approved, my lord, approves.
Maybe that on that day he has fixed 15 appeal. Pick up the matter one after another. It's
True, ma'am.
no difficult.
But
It is really a cause list which is now sent with to everybody. Don't go by that.
No.
But only thing is that if they have fixed the hearing,
On-
then without condonation, how can they?
There's no application for condemnation, my lord. I've also enclosed the appeal memo. There's
Don't put emphasis on the word application. Don't put.
I withdraw.
I can give you some judgment against you.
My lord.
There is no contemplation in the statute to make an application. Even on oral prayer, the court can do it. Provided there are the materials before them.
No, because the word here, my lord, is on being satisfied. So that
It is
belongs.
under section 5 also.
My lord.
On being satisfied that the petitioner appellant was prevented by a sufficient cause
My lord.
in not filing the appeal or applications or.
Your lordship are very correct. There's a language, my lord, of 107(4) also. my lord.
This is, it does not contemplate appeal. But you can't proceed.
No. I've given two similar orders, my lord.
You can't proceed.
No, your lordship, we have. I'm taking instruction.
When is the next date?
Next date has not been fixed, my lord. I took time on 15-7 and next date has not been fixed. And there's another matter.
We stay the proceeding.
That is what your lordships have done in the other case.
Stay the proceeding.
Your lordship, when will file and
Go, let it be condoned. Thereafter, what?
Yeah, lordship.
But you can't proceed in that. Will you repeat or repeat?
Except for this matter, the other one is 73-4.
Except this, there will be a separate order for this.
Fine.
321. Call the name.
It's,
Call the names.
Item number 21.
Other is 74.
Item 21.
This is also 74.
No, but this is multiple, in single Sokos notice is multiple.
These you are going to identify those cases because you are appearing in all such cases which are now involving a community. We will do that one day fix so that we can dispose of all those. I do not want these matters to remain there and then explode the docket of it.
No, this one last listed match up case on 5th. So now they not
We'll
posted
fix
it to
one
any.
day at 2 p.m. and we'll decide.
Only may I submit in this case? In this case, the petitioner, admittedly, there is a multiple year of assessment, so
That is what, whether the show cause will remain or show cause will not remain.
it has
Or
already
it will
been
be
adjudicated.
It will treated for one particular year.
Well, that is the contention of the petition, my lord, what I humbly pray before you.
Apart from that, there is a parallel process. State has already completed the assessment, we are in
Oh,
appeal.
that is what we have also decided.
That is on
My lord, my lord, in the so-called
audit has
reply,
completed.
when the department has issued the so-called notice, in the so-called reply, the petitioner has not avoided a single word regarding multiple assessment or parallel procedure.
This is what is a statement is against the statute. Does it, the law is required to be stated? Under the pleading, law of pleading, whether the law is required to be stated. On the face of the provision of the law and the document, whether it is in tune with the law. No difference is required. Under the CPC also, you are not required to state the law.
Already been Kerala and Madras.
You know that, are you aware? No, no, you are not aware. Read that. This is provision itself. Law not required. It's a presumption. It is applicable. Why you are saying this particular difference that they have not said in the reply? Yes.
In the meantime, Madras and Kerala have decided. So we say already matters will decide.
Let us see, that's why we wanted a badge. He is appearing in all the matters. We wanted a badge, we decide on once.
Most of the matters.
Very good order, keeping those. Yes, multiple years. Let's go on the next.
Item 22. 22.
Then I'll be faster to order one. Karnataka is doing a constant.
Yes.
Item 23.
Another 3% time. This is 60.
Item 24.
Below, I'm appearing on behalf of the petitioner. I am an exempted entity, below. Am I audible, below? Below, this is a demand under section 74. Penalty and interest along with the demand, which is coming below 37 crore as the demand against the NHI, which is actually the exempted entity. And here the demand is on 36.6 crore and the penalty is also under 36.6 crore. And the issue below is very limited because I am already exempted. Just because I pay an amount to the CAMPA, which is a statutory demand under a special statute of 2016, this demand is invoked against me only on that statutory amount, which we paid below from the year 2017 to 2020.
Yes.
And your lordship will turn to the page number 44 for a moment.
The lordship on behalf of the Department of Opposition, what will let a copy may be served.
Oh, copy has not been served, sir.
Opposite party number 2.
Opposite party number 2, it has not been served. And he has come after noticing the matter.
Okay, Balot, then I will give a copy because it has been already given pursuant to your lordship's.
The GST and Central Excise.
Balot,
They have a separate set of lawyers.
Balot, I'll give it, Balot, then my learned friend.
Give it. The copy served in course of this week, Monday.
Monday. I have obliged, Balot.
Oh, it's Monday. Next.
5.
25 regarding cancellation of RC.
Give. Have you checked? Let us see from the prayer. Asking the cancellation, yes.
26.
Not 6 months. I'm very confident.
Yes. Yes.
Item 27.
Yes, after 2 weeks. Yeah. Next. 28. Fulfill. Then
Item 29.
Wait, legal. It's an inter-court opportunity. Wherein the order passed by the Honorable Court is under Annexure 1 and their referral losses. Very briefly, our losses to fact I'm submitting. In Dingepur Gram Panchayat also in Khurda, the no confidence motion was moved by majority of members against the Sarpanch. Now, there was the sub-collector concerned who has to take decision, he didn't take it. Then the ward members, those who wanted for no confidence, they approached this Honorable Court. Finally, this Honorable Court directed the sub-collector to act according to section 24(2)(c) of the Gram Panchayat Act, which mandates. Can I proceed, my lord?
oh, no, I am hearing you
My-
and I am reading the impugned judgment simultaneously. Don't worry.
My lord. So the Honorable Court directed
So there was a dispute with regard to the signature appended on the attendant register.
attendance register that
So that
that is there before your lordship in the writ petition it is annexed. Now my
And
grievance is that your
there is an allegation. So the single bench has directed that you take steps
that order.
and examine
My
why
lord,
you are challenging. You are a sarpanch.
No, I'm not Sarpanch.
Then-
We are the ward members, those who have moved. No confidence against the Sarpanch or
Yes, and you have obtained the signature which was alleged to be a forged one.
that is the Sarpanch concern.
Correct, but there was because those persons have come forward and say, I have not put the signature.
Yes, your lordship.
So
My grievance is that your lordship,
what is your grievance?
my
Let him go and take a.
may I make a small submission, ma'am?
Where is this? What submission?
The persons, those who have alleged that they have not signed, even they have lost an FIR to that effect.
Correct.
Now the question is that the Honorable Judge directed the collector without examining that even the reprehension filed by the Sarpanch is not maintainable. Now directing the collector to without
What happened to a resolution taken on the basis of that particular 1/3 signature? What would happen? Just imagine.
Man,
You are at one go, you wanted, once they have filed an FIR, the investigating officer will take care of this. We are not concerned how it is relatable to this, but you go on reaping the benefit on the basis thereof.
the Sarpanch is reaping the benefit.
Not reaping the benefit.
Yes, your lordship. My lord, my
So
submission.
you go, show us the 1/3. If the person has subsequently withdraw, where is the difficulty? They can.
The difficulty is that, your lordship, now
You have no majority now.
my lord,
That's all, 1/3.
1/3 we have majority ward
But-
members.
No,
Sarpanch has not majority.
no.
Yes, ma'am.
Because you have put the signature, these persons have denied.
These persons have denied.
So it goes down to 1/3.
My lord, so that is exactly my prayer. So the Sarpanch is having no majority, my lord. That is my prayer. My grievance is against Sarpanch only. We are the ward members.
No, this attendance register, I do not know. This is a meeting in the attendance register.
Yes, this is
What is the grievance?
the grievance is that, your lordship, ward members have said that this is not the signature, never signed it, and to that effect even lost an FIR. This is
Where they put the signature? Which signature they said that they never
that is
signed?
in the writ petition, your lordship, page 20. That is
Tell me in the requisition notice or in the
attendance.
Attendance on a day.
On a day. Now, on that basis, Sarpanch wanted to say that 3 consecutive meetings we have not attended, so we will be disqualified. Accordingly, our move he wants to frustrate. That is my prayer before your lordship. This is entirely created.
Whatever is created, if it appears from the record, since last 3 meetings you were absent, if the law presupposes that you are liable to, your candidature is liable to be cancelled, then law will take its own course.
Now the thing is that, your lordship, the order passed by Honorable Court, even we are 13 members, it is not disputed. The law says 1/3 quorum is to be there. Your Lordship may kindly see in the Writ petition, page 15, only 3 ward members are there. Even 1/3 quorum is not there. In spite of that, if there is a direction to the collector to consider when prima facie it is not maintainable. The Sarpanch has made a representation on 17/7/2025, annexing the attendance of 17/7/2025, page 15 of the Writ petition. Your Lordship may kindly see. In page 15, your Lordship will see three ward members are there. We are 13 ward members, one is deceased. So left 12. 1/3 requires 4. Now we are 3 ward members. Rule 7 says there must be 1/3 quorum. If quorum is not there, the meeting is to be adjourned minimum to 3 days after. In spite of that, he made a representation on 17/7 itself on the same day to the collector, which is prima facie not maintainable. And collector on that basis.
Section 20, Rule 24, whatever of the Gram Panchayat Act,
Right.
Odisha Gram Panchayat Act, talks about that 1/3 must make a requisition annexing the resolution
Right.
and then sending it to the sub-collector
That has been done.
for the purpose of calling the meeting. And the sub-collector is obligated not only to issue a notice, but also the resolution, the copy of the resolution and the requisition, and the meeting would be held
Right.
in his presence. Now, according to you, or what it appears from this, that there was some dispute on the veracity, genuinity of the signature put on the attendance register.
This is by the Sarpanch. The ward members who have moved before the sub-collector, that has been finalized. No confidence motion has been fixed to 22nd of August, and that is already over.
Then what is this meeting?
This meeting, the Sarpanch has created to show that the ward members, those who are moving,
Who are moving a no confidence motion, they are already disqualified.
they are to be disqualified because of non-attendance.
Go and contest.
I have no objection, my lord. The thing
Go and
is that
contest.
the collector, by virtue of this order, now has proceeded with the matter without examining that even the representation quorum is not there, signature is not there, nothing is considering directly.
Sir, some signatures are disputed.
Disputed, and
That's all manipulation and the forgery.
but your lordship, the quorum is to be seen, it is visible.
No quorum. Forgery for that. One single person who alleged forgery.
Yes, that is there,
That's enough.
my lord.
Quorum is required for creating a
My
forgery.
submission is that,
What are you talking about?
no, my submission is that the quorum is required for the Sarpanch to show that minimum 4 members were. That is also not there.
That is the I do not know. That is a separate issue with this. Now they have already fixed the. Let them. The court has said that so far as this allegation is concerned, it has to be investigated.
That has not been done.
So this is what a direction is given.
The collector has fixed it to 20th of August.
Sir, this is what the opposite party will consider and thereafter take a decision within a certain period, examining all the defense and such, including the allegation of manipulation and forgery,
for
for which the FIR is stated to be
not
lost.
being done, my lord. My grievance is that, your lord. My grievance is that the collector has issued. My grievance is, my lord. The collector has issued notice on this 17/7/2025 to the ward members and has asked them to come to on 20th of August to disqualify them, so that the no confidence which has already been fixed on 22nd will be frustrated. That is there, your lordship. That is there.
Sir, the question is that defense and all, everything is to be considered. Now disqualification, whether it is a prospective or a retrospective, you take your plea.
Now,
Sir,
you
cannot presume. Suppose you are disqualified. Will it invalidate your requisition on that day? Requisition would be valid.
No.
Subsequent, the difficulty would be in the meeting. Whether you will be able to present in the meeting and vote or not. I understand. Your contention is first removal, you take it, then disqualification.
No, let the collector at least verify the veracity of annexer.
Who is for the state? Unnecessarily. And the writ petitioner is to be notified. You are the opposite parties in the writ.
Right.
Give a notice to the. We are not going to stay. Notice 2 weeks.
Item number 30.
My lord, my prayer is that, your lordship.
No stay.
Then your lordship on 20th, your lordship may call it on then, my lord, today.
Yes.
And
No 18. Short notice, can you be able to serve them?
Yes, my lord.
Serve, short notice, 18, deposit. You serve,
My lord, lawyer who has appeared for writ petitioner, I'll give him a copy.
you give the petitioner as a, if he refuses, then
Petitioner may not receive a copy from me. The opposite party 10 may not receive a copy from me
why?
personally, because we are not in, because I am moving now.
No, I said, after hearing the counsel for the appellant, the appellant is directed to serve. You just writ petitioner opposite party, you serve. Call the next.
Item number 30.
And actually, this matter was adjourned to 25th August, Milad. They had to file the requisites. Now, nothing is there in the list, Milad. They have filed wrong requisite in favor of opposite party number 5 instead of OP number 4 and 3. They have to file proper requisite.
Where, who is appearing? They are not. Where is Mr. Basudev Mahapatro, Mr. A.K. Patro and P.K. Panda? Pass over.
31.
228 days. The name of the council appearing for the other side is where they are not interested in this.
Who?
One. Mr. Pranay Kumar Mahansu, his name is reflected.
Yes, I am there.
Oh, sorry. He's sorry.
My colleague,
I'm sorry.
my junior is up here. This is the objection I am giving that.
It's our copy.
Serve him a copy. Serve him a copy. We are keeping this matter on Monday. We'll decide it.
Today,
Not today. They have to peruse. They have to peruse the,
not satisfactory explanation is there.
or whatever. They have to peruse. If they can come with the rejoinder, better particulars. You have opened the opportunity by using affidavit. Monday, come.
Wednesday.
Come on Wednesday.
Item 32.
Take this counter affidavit on record. Yes. To the application for condonation. Yes.
It's fine. There is a delay of 299.
32.
Yes, who is for the other side?
Yes, is a lot. I'm appearing.
Yes, what is
Today only will file an objection to this.
opposition within 2 weeks? Rejoinder, if any, within a week? Matter to appear after 3 weeks. Yes, next.
Item 33.
If the matter, if I withdraw the lordship's memory, then the lordship has a elephant memory, my lord, that I know that from every dictation and order. But this case has been heard, that is a Anganwadi, small case, my lord. She is working as a Anganwadi worker. Only case, my lord, that, my lord, kindly see case paragraph 2. Your lordship heard the matter and kept it for the orders. But my lord, on the 61 page, this is my case. That advertisement issued on 22/6/2016, inviting application for engagement of Anganwadi worker.
What do you have to say?
My lord, they are saying that why on the date of verification, my resident certificate is there. The advertisement says, my lord, that not to be submitted along with the application. Must be that I have given the English translation, one that area. But they are
Private
saying-
Respondent has entered appearance to a caveat, but they are not.
Have you served the private respondent?
Yes, they have hard, my lord, everything has completed.
Who
They have-
has, who is here?
My lord, he is not in.
Anurag Pati, the one.
Anurag Pati, he is on that, your lordship.
You just
If I-
inform him. You just inform him.
Yeah, I am.
So we are keeping this matter on Monday. You just inform.
Withdraws your lordship's memo, your lordship said that this will be, so
Oh,
he's not
I
coming.
know,
because
I
he
know.
won't Comment.
If you come, you just inform me.
Yes.
Come on Monday, I will do it. Don't worry. We are keeping this matter on Monday.
Well,
Just inform.
Yes, I will. I have asked, inquired, he said, no, I am not going today because it will be allowed, so that's fine. Okay.
34.
They are now going to terminate my services. That is,
Come on Monday. That's
Yes.
because tomorrow is a holiday.
Yes.
So first available day.
that's why I am pressing.
34.
CGC, Union of India.
Mr. Mohan.
You are for?
Yes, appellate. Union of India.
How much days delay?
14 days.
Have you served?
No.
Served the notice, application? You are for?
Respondent.
Respondent. You are for the respondent.
I'm something.
Serve it. Just peruse it, come on Monday, we'll decide. 14 days.
Both the respondent.
No.
No, only one respondent is there. Ajit Kumar Kutia.
Both.
Why it is not showing? It's only one name. Item number 34. Okay. Anyway, you are appearing for both?
The respondent.
Yes. Give me a copy.
Already, sir.
Come on Monday, go through it. It's a small matter, do 1 minute.
Item
13 days.
49 days. 49 days delay.
14?
149.
Oh, 149.
No, only 49.
Achha, only 49. Yes, come on Monday.
Item 35.
Withdrawal. The advocate and record, what's your name? What's your name?
Manas Ranjan.
Manas Ranjan? But your name is not reflected. Acha, Mohin. Yes. Next.
Item 37.
36 already.
Yes.
Please, Your Lordship. Your Lordship, in this case, my lord, Your Lordship's last order was on 28/9/2020, my lord. No counter has yet been filed, my lord.
Yes, my. Can we be granted for filing?
Is the first extension or second extension?
It listed after, before this once only. Once.
No, there was a direction for affidavit. Now this is the first time extension.
It's the first extension.
Yes, 3 weeks. 1 week for rejoinder after 4 weeks.
38.
Deeply applied.
Yes. Yes, not today. Next.
Item
38, I pray for maybe taken up.
Tuesday. Next.
Monday, because Tuesday I have some problem. Monday.
And Wednesday. No,
Item 39.
I am for the OP in this case, my lord.
Who is for Sudeep Kumar Sarangi?
And the passport, you can not.
Yes, not today. Next.
Item
Next
40.
date, next week. We'll give.
Item 40.
Newspaper can I mention, madam?
Yes, it will be there.
They mention the case, but not available, madam.
Next.
Item 40.
40, I am for the opposite part.
Yes. Next week.
Item 41.
Yes.
The Honorable Court directed to the wish to the petitioner within 1 month.
They have not paid.
Not bad.
Where is the order?
Already is can you see?
29/2/2024.
My lord.
Oh, you have passed an order. Yes, well, who is for the LS contempt now? Notices have been issued.
My lord.
This answer for contaminant is
Notice has already been served and he.
No, who is a part of contempt?
Sarpanch.
Then why you are appearing? You are not supposed to. This is a case of contempt. It is not the state lawyer who will appear. They have to be engaged separately.
The notice has
Yes, service.
issued. It has been already sufficient. Notice has already been sufficient. But still she has not been appeared yet. So.
Huh? When the service is affected, show us. The advocate to go and take an instruction. Why AGA will to go and take an instruction? Yes? No, this is. This is the receipt is there. See, this is our. No, this is acknowledgement by addressee. This is not, this is a Purnima such and such of Balasore. And this Purnima has put a signature. Date. He's a contempt, huh? No, not police, immediately. By an order dated 12/8/2000, no, sorry, this is.
Senior advocate, Joint Kumar. Lordship, one of the after he will argue the case. He
Yes.
by personal difficulty.
Adjourn for 2 weeks.
So,
Give a date after
intimated
2
to
weeks.
the-
2 weeks.
Intimate to continue.
Second,
Yes.
second September.
Next week, date is
One.
Next week not possible for us. He has a difficulty for this. We have a difficulty for next week. So we are keeping thereafter.
On second September. Item 43.
Well, intimate to continue.
Next.
Item 43.
May I please, Your Lordship, I'm appearing for the petitioner in this matter. Your Lordship, occasion, the Honorable DSGI has sought 4 weeks time to file the counter affidavit. However, the counter affidavit has not been filed.
Mr. Vatsal,
My lord, item 43 on behalf of learned DSGI, my lord. We have sought for certain instructions, my lord. We need some more time. My lord, I pray for 2 weeks more time to file my counter. My lord.
First extension. 3 weeks
Well,
to file.
item 44.
Oh, bless Your Lordship.
May it please, Your Lordship. Madam, this case, Your Lordship, my lord has issued a notice to the Qatar Municipal Corporation. Lordship, directed specific instruction whether the illegal construction that has been made over the public land and for the purpose of the demolition of that property, the CMC filed a suit. Thereafter, first appeal, thereafter, second appeal, Your Lordship, the private opposite party in the Supreme Court, and there is a direction of all the court that the building should be demolished. And the private respondents, who are the encroachers, they have filed the undertaking in all the proceedings. That on the event, I shall.
Now demolition is there. So now the execution has to be put in.
My execution case, Your Lordship, has been dropped.
Why?
Because before the builders seniority and cut off, Your Lordship.
Why it is dropped?
It is my instruction because we are the resident of that locality and the execution case has been filed in the judgment debtor is the private respondent and the CMC is the decree holder.
No, he's a decree holder. The judgment debtor is the private respondent.
Right.
Now, why it has been dropped?
It has been dropped because it has been stated that the decree holder got the possession of the property.
Oh.
It is only in that time, but the decree is demolition of that. Whether the decree is satisfied or not.
So what is this? Now they will take care of this. Whether they will utilize that particular structure after regularizing it is one thing, or they will demolish the structure and make
It's not a single frame. Made in a public purpose.
Which one?
This same issue, same prayer.
Where is that? What is that?
Petition WPC number
So
183.
tag it and keep it after 10 days. We'll see to it. Tag this both.
Both. Neither related to that proceeding. Now arising out of this, that is altogether different procedure.
No. He says that relating to the same plot,
Yes.
same structure. So it is there. Let us take one go.
Item 45. Sorry.
Yes.
The resident has filed 130.
Or whatever, let us see.
Item 45.
Yes.
I'm challenging the Annex 1, page 12, regarding non-utilization of the Moha flower minor, has demanded 68 lakhs, 64,084.
64 lakhs 84,000.
Yes, ma'am. I'm ready to willing to deposit 50% within one of the and till then my distress warrant and is there.
What?
And the rest amount I will be with the installment.
Yes, what do you say? Yes. He's ready to give you. Only thing is wanted a
In other words, the ventilator services is already on a ventilator. So he wanted this ventilator to continue for service. For the service. So tell us 50%. And then 50% in 3 quoted monthly installment. Yes. 50% within a week from date.
Within 4 weeks. Within 15 days, you also.
Within fortnight. And the remaining What is it? Adjourn after 40.
Item 46.
As to this, issue notice to the OP number 5, which is the inclusion.
My lord, sir, I am appearing for the opinion 5. I filed my opinion, but my names are not been here.
Section says that what is there in the name. So why you are so much possessive about your name to appear?
My lord, sir, the notary.
You are appearing is can be denied you from being heard, even if your name is not appearing. Why? That's a ministerial, they will do it. What do you say? Tell me.
My lord, sir,
You have been served with a copy?
yes, my lord. I'm filing the counter.
What is the matter? Matter is correct. Then he is that will to file a counter. 2 weeks. You also want to file counter?
Yes.
2 weeks.
Right.
Rejoinder, if any within 1 week thereof.
My lord, I'm
But we are after 3 weeks.
yes, permit to submit one. My lord, subsequently, civil suits have been.
Bring it on record by way of reading.
My lord.
Do it.
Item 47.
I may be pardoned, Your Lordship.
I have received the Parawise comments. 1 week time may be allowed filing of counter.
Yes, first extension.
Your Lordship, the interim order to continue, my lord. And for the petitioner, interim order.
This is the first extension. Last time, the direction was passed to file opposition. Now
Yes,
you are
my lord.
saying First extension.
Yes, my lord.
Yes.
It will be the first extension.
How much?
2 weeks.
2 weeks, 1 week for rejoinder. Matter to appear after 3 weeks, interim order till next day.
Item 48.
Bless, my
There are no interim.
Interim order, if there be any.
48.
I appear for the writ appeal in the item number 48, my lord.
Who is appearing?
My lord, I am appearing for the.
I could see your mouth and the hand, sir.
Sorry, my lord. On the last occasion, my lord had passed a direction for us to serve the copies on the respondent. We have completed our service, my lord.
Yes. Is the service complete? Is the service complete? What is?
This and deliver.
What about the other? Who is for the Union of India?
Myself, sir. I'm actually for the union.
Yes. Who is the respondent number 8?
Like not appeared yet, but the short one.
For the Tribal Development Agency.
Who is respondent number 8?
Project administrator.
No, project administrator. No, yes, integrated tribal.
Development agency.
Development.
Yes, for them on a state.
My lord, you have received instructions from them, my lords.
Yeah.
Yes, sir.
So what is the instruction? You want to bring it by way of affidavit?
Yes.
Yes. Affidavit. You are appealing for one.
One lord.
Yes, within 2 weeks, 1 week for rejoinder, 3 weeks.
Deeply.
Item 49.
Deeply obliged, my lord.
Well, the acknowledgement due card has not got that. Complete the services.
I'm bidding for OP1. It is written 1 mile. Today, that is for appearance. Today, I'm appearing.
Another respondent, sir. The bank.
The service is not complete. From at least neither AG nor the under.
1 and 7. 1 and 7 yet to be received.
One is appearing.
Yes, I know.
Then 7.
No difference. 7.
7.
7, anybody?
46. Central Postal and that is not trusted.
Cooperative that is, they have a panel of lawyers.
Do you know anybody who has?
Yes, please.
Can you bring him?
Mr. Baidhar is appearing.
Can you bring it? Come bring him on Monday. We are keeping this Monday. We'll expedite it. 50.
Item 50. Item number 50.
Tablet is there, sir.
Yes, yes.
He ought to be arranged.
Mr. Misra.
When the
No, he was there in the old building. He was there with me, but he got good.
Then come on Monday.
Item 40, your lordship has kept it to next week, my lordship. It's a partner matter, any time.
We recorded partner.
No.
Item number 30 is to medical Wednesday. I'm paying for our next week.
Yes, he's already there.
Yes,
Everything is gone.
Yes. Item number 20.
The matter about.
That matter, my lord, dispute the seniority between two batch of equals. One, the two batch of direct equals of one is of the year 2011, 12, 13, and another is of 15, 16.
Oh.
It was just pressing that.
So what are these matters? What
The
does it
batch of matter challenging the recent judgments. Is the other day, hearing these matters.
Yeah.
And the matter should be taken up so that it can be finalized.
So we wanted, what we wanted that if all of you give us short notes of
Yes, sir.
argument.
I have prepared a short note.
So that would be very easy
Then
for us to
Then
dispose of the matter.
Yes.
Oh, yes,
Yes,
that
and
will
we will
be
come back.
That will be a short argument
Yes,
that we will dispose of on the.
Yes, yes,
Then
yes.
So
we'll
can
come
you
back.
file your written notes of argument?
By Monday, we'll.
I have my
By Monday.
judgments and compilations every
Please give me.
No, I have given the
So that
judgments.
at least give me also a time to go through it, so that to just minimize.
I have given the judgments.
Of course, my judgment you will also prepare independently, but I have prepared a note. I do not sit for that.
We just give it to you. Also give it to me. You have a.
Why not your also?
Monday we'll give it.
But
By Monday.
No, we permit you to argue, but
Yes,
after reading the entire one, it will be a minimizing.
Yes,
I get your point.
That
In
is.
fact, all these, we are the appellates.
Huh.
Mr. Das, Mr. Tripathi and myself, we exchange our notes and we can prepare at least for your lordship's convenience.
Composite.
Yes.
No,
So on Monday itself.
you gave on Monday.
Yes.
I am fixing this matter on Wednesday.
Yes.
At 2 p.m.
Man.
No difficult.
No,
Mr. Da,
No,
you also prepare.
Yes.
You also prepare your notes of argument.
Only difficulty that they are proceeding to have reviewed it based on that.
What is this?
The gradation list they will prepare. Now they will.
No, they will not finalize.
Yes,
That is said, man.
In terms of lordship's observation on the last occasion, I have written a letter to them. They are not proceeding. Tentative list has been filed.
In them, they have issued a letter.
Only
They have issued a list.
it will be a result of the.
Yes, nothing is happening.
This is a letter.
It's taken.
Yes.
This 12-8, they want that.
They do not.
That is, I have handed over one to my senior friend, Mr. Das.
It's coming up on next
Wednesday.
Yes.
Will it be? Wednesday, 2 p.m. It will be there.
Thursday, if it is not inconvenient to your lordship.
Yes.
Thursday.
Thursday.
Yes.
Yeah,
Absolutely not. No problem.
Thursday is.
All agrees.
My Monday at 5. Today I'm handing over my compilation of
Yes,
judgments.
please give, so that I will invest time in the.
I have given a judgment punch last week.
One matter passed over, but item number 30, disclosures are not filed. Item number 30.